In this lesson, we'll discuss an important exclusion from Article 2's scope, service contracts. Article 2 doesn't apply to contracts for services. Instead, these transactions are governed by the common law of contracts. However, many contracts involve both the provision of services and the sale of goods. Two tests are used to determine whether Article 2 or the common law governs one of these hybrid contracts: the predominant purpose test and the gravamen of the action test. The predominant purpose test is the test used by most courts. This test focuses on figuring out the contract's predominant component. If the transaction is mostly about selling goods, with labor only incidentally involved, then Article 2 applies. On the other hand, if the transaction is primarily about providing a service, and the sale of goods is incidental, then Article 2 doesn't apply. Courts will consider various factors to determine a contract's predominant purpose, including the contractual language, the nature of the seller's business, the product the purchaser entered the bargain to receive, and the amount charged for goods versus the amount charged for services. Let's see how these factors apply by looking at some examples. Imagine that a homeowner hired a company to install a security system in her house. The contract referred to the homeowner as a purchaser and provided that the seller was to deliver and install equipment in the home. In this scenario, the contractual language referring to the transaction as a purchase of equipment from a seller was more indicative of a sale of goods. Thus, the transaction was more likely predominantly for goods. Now let's add that the main thrust of the company's business was designing and selling security systems. Because the seller's business was primarily focused on providing goods, and installation was incidental to that end, the transaction was more likely for the sale of goods. Next, imagine that the homeowner was a master electrician who could have easily installed a security system. However, it was the company's policy to install their equipment. Here, it was the security system itself, not the installation service, that the homeowner was seeking. Thus, the transaction was more likely a sale of goods.